ഇതിൽ ഇറങ്ങുന്ന സോ
Yes, yes, you're audible.
Good evening, all.
Good evening.
Yeah. Is my voice audible?
Yes, yes, sir.
Clear? Okay, then order. Let me share the thing. Just give me a second. Okay, why I couldn't share? Hello. Hi. Can you make me as a co-host? I couldn't share my presentation. Yeah. Okay. Oh. Okay. So till then, we will have a quick overview about what we have discussed in our last session. So we were seeing about the new module, which is business law. So what is a business law? It's a the law enforcement applied for no applicable for the business purposes. So either of the parties, that is no whoever is in the trade. So both the parties or no like more than two parties, they have to come into an agreement or a written document kind of a thing, like a contract, to make it valid in case of any disputes happen. So that is what is contract all about. So it is not commendable under business law. It is not it's not lawfully accepted anywhere. So there are no few documents and few agreements signed upon by both the parties who are whoever is trading, and few documents are valid, few documents can be made lawful, but few are not it doesn't come under any law. It is just a sign of agreement, both the parties just agree to get into a business, but the business has not happened. Only when the business has happened or some kind of transaction happening, then that becomes a valid contract. Otherwise, it just stays as an agreement, and that is not a contract. So that is the difference between the agreement and the contract. And then we were seeing about what are all the sources of the mercantile law in India. So how, from which sources, these laws were, enacted, and it was, guidelined by the Indian government, the law of the Indian government. So we got, the resources from the English mercantile law and the Indian status law. That is, the different businesses done in Indian subcontinent. So we have taken excerpts from there, and from no other judicial decisions, and no from customs and usages. So what customary duties and responsibilities they are performing, and the usages of the documents, and no other logistics and trade related factors. So from these sources, the business law of India, for Indian subcontinent, it was enacted. So when it was done in 1872, and all states of India except Jammu and Kashmir. So initially, in the initial period, it was applicable to all the parts of India. So what is a contract? All contracts are agreements, but all agreements are not contracts. And we have seen that when an offer or proposal is made to the the other party by one business person or a one business entity, and when it is accepted, it becomes a promise, and this promise is written as an agreement. When this agreement, according to the agreement, when the transaction is actually happening, and that becomes a contract. And we have seen what who is a promisor and a promisee. Promisor is the person, when a proposal is accepted, person making the proposal is the promisor, and the person who is accepting the proposal is the promisee. This who is offering the business is the promisor, and who accepts the offer is the promisee. And we have seen the other rule as promise plus consideration, and that becomes the agreement. Then what else? Yeah. When agreement, which is no like enforceable by law, it becomes a contract. So, okay. So what are all the essentials of a valid contract? So there should be an offer. So it follows like a few system. That is, initial there should be an offer from a party, a business party, that is a business entity or a business person, and it has to be accepted by the opposite party who is like ready to do business, ready to do trade with the first person or the business or the organization. So when the acceptance is done, when the offer is made and the acceptance is done, then that becomes the promise. And when that promise is no like it's considered, so that becomes a document which is called as agreement. And when that agreement is no like made as a document which is enforced by law, that becomes a contract. And what are all the essential elements of a valid contract? It's an offer and acceptance, legal relationship between the parties, free consent. That is no like no one is no like doing the business under any pressure. No one is no like doing the business under any threat. But both the parties know in a free consent they are doing the business. Then capacity or competency of parties, lawful object, both has to be no like it has to be done under the lawful consequence. I'm sorry, lawful consent and lawful consideration, certainty and possibility of performance, agreements not declared to be void. That is no like the agreement whenever it is no like enacted, whenever it is no like made it had both the parties had to make sure under any circumstance it shouldn't become a void agreement. So if it becomes a void agreement, then no, there is no value for the agreement at all. So when things are not happening no within the aforementioned date on the agreement, then that agreement becomes a void. It will not become a contract. Only when no like everything is no like done and no like carried on, which is no like mentioned in the agreement, that becomes a contract, and other legal formalities to be carried thereafter. So let me see whether I can no like share my PPT now. Yeah, now I'm able to. Okay, that's great. Fine. So is the PPT visible? Yeah, is the presentation
அப்பதான்
visible?
தம்பிக்கு உடம்பு சரியில்லை அப்படின்னு சொல்லி மழை பிடிச்சி
Presentation is visible, guys.
என்னப்பா பண்றது அதுக்கு இன்ட்ராப்பாவா அது நம்பிக்கை வந்துருச்சு போல. என்னப்பா பண்றது எல்லாத்தையும் நான் நடத்திதான் அதுதானே
Guys, someone has not muted your audio. Aaron, you have to mute your audio. Aaron has to mute your audio. Yeah, okay. So all your personal conversations are being heard. Okay, fine. Guys, just respond whether you're able to see the presentation. Okay, fine. Thank you. Thank you, Prasad. Fine. Okay, so these were no like yeah, lawful consideration. Yeah. So we are starting off today's session. So as far no whatever we have seen, it is mentioned in this table. So elements of a valid contract. So just for our review process, a quick review process. So agreement, it's a no like a consent between two parties. Offer and acceptance is made, and a legal relationship is formed. So after that, that becomes a contract. And the reality of consent no like if it is not valid, it is no like it becomes void when it is no like any fraudulent practices are no like done, or misinterpretation is no like done on the document, and duress, undue influence, and mutual mistake. For any of these reasons, the agreement becomes a void document. That is no, it is not accepted. That becomes a null document. Then when it comes to legality, so there is no like there is an objective and the subject matter. And when it comes to capacity, it's not valid. That is, the document is no like not valid under, so valid for infants and no like parties who are mentally unstable. And when the agreement is made, when no like any either of the parties no like intoxicated, or no like if it is no like done between the corporations. And then no like that should be in a written format. That is no like both physical document as well as a digital format has to be maintained. Now coming to the types of contracts. So we have no like classification on no like few basis. First one is on the basis of creation and formation. So we have express contract, implied contract, tacit contract, and quasi contract. Then on the basis of validity, we have valid, void, voidable, unenforceable, and illegal. And on the basis of execution and performance, we have executed contract, executory contract. Then finally, on the basis of liability, we have bilateral contract and unilateral contract. So first one is on the basis of creation. Let's see, what is express contract? Like all about. So, where the terms of the contract are expressly agreed upon in words, whether it is written or in spoken at the time of formation, so that is called as express contract. That is no like immediately it is done. So when both the parties are meeting, there is a no like a business meeting happening, and both the parties decide to like get into the business, decide to get into trade, like then at that moment immediately like an agreement is formed, and like it can be, this agreement can be either in words or in like written. So whatever it is done, immediately there is an express contract formed. So next one is implied contracts. Implied contracts is like in contrast come into existence by implication. So there is no like thoroughly viewed, like considering all the factors, like taking time to like think about, like whether this works out or not. So all after all these considerations, then the contract is made. So most often the implication is by law or by action. So this is implied contract. The third one is tacit contract. So these are those that are inferred through the conduct of the parties. That is, conduct of the parties is usually when like both the businesses, both the like business people, or both the organizations are doing business for a long time. So their next generation also like they are indirectly they are like uh, forced to, we cannot say forced to, but we can say like under like under with like with consent they are not doing the business, because this business relationship is like continued for a longer time. So in that matter, like in that consent, the business is done. So that is called tacit contract. And then we have quasi contract. Quasi contract is created by law. So this is no like it doesn't have no these either of the parties like don't have to create a contract, but this is done by directly by law. So quasi contracts are strictly not contracts, and there is no intention of parties to enter into contract, but it is a legal obligation which is imposed on a party who is required to perform it. So, for example, either of the like the party, either of the business person like has done some like say a fraudulent mistake, or like or it has like because of like without knowledge or without any like idea about like what has to be done, they have not done some mistake, it's a mistake, right? And sometimes like purposely they have done something. So in that case that now the since it is a contract, now the case goes to the law, and the law is like punishing that particular person or the business or the organization to like take actions, that is like compensate the loss which these people has created for the other party. So it becomes a quasi contract. So this contract can be like asking this person, that is who has done like by mistake they have done or by purpose they have done. So they're asking these this business entity or a person like to go on with the contract, whatever is mentioned in the contract, to go on with that, so that the other person like doesn't have to like get a loss, or like don't have to like miss out the opportunity. So this is quasi contract. So this is not done either by either of the parties, but it is enforced directly by the law. So now on the basis of validity, so we have the first one is a valid contract. So it's an agreement which has all the essential elements of a contract, and this can be enforced by law. Now, Under valid contract, or like there are many things. So, for example, no, like see, considering all the essential elements of a contract. So essential elements is now like at least two parties has to be involved, and in full consent they have to get into the business, not by like in a forceful manner, or not by like whatever, like not under any threat. So under full consent they have to get into the business, and it had that has to be like some transaction happen, like so if one person is like getting into the business and other person is getting benefited out of it, but not paying back either as a money or as a goods or as like some product or as a service. So if nothing is happening there, then it is not considered as a business. It's a service done. So there is no business happening. In that case, like it doesn't become a valid contract. It just becomes a service, and that service is recorded in the document. Then is void contract. A contract which ceases to be enforceable by law becomes void when it ceases to be enforceable. That is not like when things are not happening which is mentioned in the document. That is no in the contract, whatever is promised by both the parties. So either of the party is not no like strictly following that. So in that case, no, the contract becomes a void one. Or no, like they have done some fraudulent activity on the contract. They have misinterpreted something, or they have changed something. So purposely or no, like by mistake, whatever. So then that contract becomes a void contract. So thus, void contract is one which cannot be enforced by a court of law. So when it becomes void, then no, like it doesn't have any law enforcement. So under a mistake of facts, consideration or object of an agreement is unlawful. And then agreement made without consideration. That is, no, the other party's consideration is not sought. So without the other party's consideration, consent, the agreement is made. So that becomes a void. And the agreement is in restraint of marriage. No, like under no like uh, under any legal no like relationship, it is no like forcefully. No, the other party is being no forcefully made to get into no like a business contract. So that is no like completely void. Then restraint of trade. That is no like the parties are no like restrained from making trade, maybe for some time or for the no like entire lifetime, whatever it is. Then restrained legal proceeding and agreement by wage of wages. So all these no like comes under the void contract. Voidable contract. So defines that an agreement which is enforceable by law at the option of one or more parties, but not at the option of the other or the others is a voidable contract. That is, so enforceable by law. Voidable contract is enforceable by law, but at the option of one or more parties, but not at the option of the others or other voidable contract. That is, not any third person is not like made to get into the this business relationship. So result of coercion, undue influence, fraud, and misinterpretation. So these things can be the reason for the voidable contract. It can be voidable when these things happens. No, it is made voidable. Though both the parties know like follow exactly the same whatever is mentioned in the contract, the contract becomes a valid contract. It doesn't become void contract. But unless or otherwise, no like like uh, without the knowledge of any of the party, when the third person or a third party is no like purposefully getting into this contract, then that can become a voidable contract. Then is unenforceable contract. So where a contract is good in substance, but because of some technical defect cannot be enforced by law, it's called an unenforceable contract. So these contracts are neither void nor voidable. That is writing, registration, or stamping. So this is no like these are all the contracts, but no like it cannot be void or voidable. Under any circumstance, it cannot be no like void or voidable. Why? Because no like when mistakes happens, so it can be corrected. On over time, no, it can be corrected. No, like justice can be sought for the no the concerned parties, but the contract never gets a void or a voidable one. And then is the illegal contract. Contracts those which are forbidden by law or illegal contract. So when either of the business parties get into a trade,
This is a simulation game set in a virtual world and does not represent real life. Please play in moderation, take frequent breaks, and play responsibly.
Mr. Adil Shanawaz, please mute your audio. Adil Shanawaz.
അടുത്തതിൽ മറ്റേ ലോഗൗട്ടില് എടുത്തു വെച്ചിട്ടില്ലേ?
Mr. Adil Shanawaz, are you hearing? Okay. Guys, make sure you are muting your audio, because like the total like class gets like disturbed. So make sure you're muting your audio. Only if you have like anything to like discuss related to this session, if you have any doubts related to this session, you can unmute and speak. Just like don't have to unmute and speak, just raise your hands, then I can like get in touch with you. Otherwise like please don't like unmute your audio, because all the background noises it disturbs the class to a great extent. Clear? Okay, fine. So we have like the screen has. Let me share the screen once again. Okay. Yeah. So when dealing with products or any kind of service which is like illegal under law, so that becomes a contract itself becomes a illegal contract. So these are hence void, because because these products or services, whatever is agreed between these two parties, so that is like not okay. That is it is not acceptable by the law. So the contract itself becomes an illegal contract, so that it becomes a void contract. Because of the illegality of their nature, they cannot be enforced by any court of law. In fact, even associated contracts cannot be enforced. So contracts which are opposed to public policy or immoral are also illegal. So opposed to public policy. So the government guidelines, it will be having few public policies. That is like uh, restricting like a few businesses from like the usage of land, which is like meant for the deserving communities, or for like for other tribal communities. So acquiring that land without like a proper consent, or like having a contract for a business, that completely becomes a illegal contract. So in that case, that becomes a void contract as well. Then we have to keep in mind, all illegal agreements are void agreements, but all void agreements are not illegal. Okay, so on the basis of execution. So executed contract. An executed contract is the one in which both the parties have performed their respective obligation. So once like everything is done, that is as per the contract, when both the parties have like done everything, that is like performed the business activities, uh both the parties have like got benefited out of the business, whether it's a profit or loss, like that doesn't matter. But whatever is mentioned in the contract, so that has been like done, that has been like they have performed the duties. So in that case, the total contract becomes an executed contract. So that is done. Whatever is mentioned in the contract, that is done. Then is executory contract. So this contract is one where one or both the parties to the contract still have something to perform their obligations in the future. It may be like like say after sales service, or some like kind of a promise or a warranty which is like given to the other party. So whatever it is, even after the actual business has transaction is done, the actual business is done, there is something left over to be continued in the future. So in that case, that contract becomes an executory contract. So thus a contract which is partially performed or only performed is termed as an executory contract. So finally, on the basis of liability, unilateral contract and bilateral contract. So let's see first what is unilateral contract. A contract is one which only one party has to perform his obligation at the time of the formation of contract. Then the other party having fulfilled his obligation at the time of the contract or before the contract becomes into existence. That is, when the time of the formation of the contract, so either of the party, any one party, so they have to perform the obligation in the initial stage itself. So then it becomes a unilateral contract. That is, the one party at the initial stage itself is agreeing to something and performs it, not only agreeing to it, but performs the activity actually. Then the remaining things, whatever is mentioned in the contract, then those activities, that has to be performed on a later basis. In that case, it becomes a unilateral contract. Now, what is a bilateral contract? So it's a contract in which the obligation on both the parties to the contract is outstanding at the time of the formation of the contract. So it has to be done at the initial stage, but it is not done. So both the parties, not just one party, both the parties have not done that yet. So still the thing is pending. It means the business haven't even started on time. So that is what now we have to understand. So that becomes a bilateral contract. Bilateral contracts are also known as contracts with executory consideration. So anyhow, those things has to happen as soon as possible so that the the following business activities will go on. So unilateral, either one of the party has performed the action, or bilateral. So both the parties yes, they haven't done anything. So in the initial stage itself. Then finally we are coming to types of offers. So though we have seen what is offer in our previous session, in our last session, offer is something when a business entity or an individual business person is coming with a proposal, a business proposal. So there are many types of business proposals. So it can be based on few factors. Depends on the situation. It depends on what type of business these parties are going to enter, or it can be it can be a private contract or it can be a government contract. So many factors are there to come with a right type of offer. So let's see what are all the different types of offers. The first one is express offer. That is initially, immediately, which is done. An offer which is expressed by words, spoken or written, is called an express offer. That is, say M says or writes to N, I am ready to sell my house to you for 1 lakh rupees. Immediately, on the spot. So this is happening. So for example, as I said earlier, like I said a scenario. So there is a business meeting happening and one party comes to meet the other party in a venue, and they are discussing about the possible business relationship, where they can make it out. So immediately one party is happy with the the talk, business talk, and immediately the party is coming with an offer. So it can be in words, or it can be in a written document, whatever it is. So that becomes an express offer. The second one is implied offer. Same like express contract or implied contract. But this is just an offer. Contract is something where both the parties have come into the, like they have legalized the agreement. But this one is the first stage of the contract, which is the offer stage. Second one is implied offer. So if the offer is made by the conduct of the parties, it is called implied offer. That is promising, like that the conduct is promised. So if a transport company runs buses on a particular route, so there is an implied offer by the transport company to carry passengers for a certain fare. So this is there is no contract, actual agreement or a contract signed between the bus owners and the travelers or the passengers. There is no such contract, but it is an implied contract. So by the way of conducting or performing the duty or performing the responsibility, so this business, this business entity or this business person is giving a business offer to the other party. So that is called as implied contract. But there is no contract there. This is an offer. The third one is specific offer. So it is where an offer is made to definite person, just one definite person. So it's a specific offer. It can be accepted only by the person whom it is made. That is this is not between between two business parties. That is two businesses, but between a business and a party, a business and an individual, or a business happening between an individual and an individual, not between two businesses, or not between two agencies, or not between a government, or not between the corporation and the government, a corporate and the government. No, this is not completely between either two individuals or a business entity and an individual, or government and a business individual. So in this case, it becomes a specific contract. So only that person to whom the offer is made, only if that person accepts it, then it becomes a proposal offer. And then is the general offer. A general offer is one which is made to be world at large or public in general, and not to any specific person. Mr. Aaron, Mr. Aaron, please mute your audio. Mr. Aaron, can you hear? Please mute your audio. Okay. So this is something where a business or a business or sometimes an individual promises to the public, promises the public or a group of individuals, in general, that this person will do something for them, or this organization is going to offer something to the customers, to the potential customers, or to the general public. So through advertisements for tracing a missing person or thing, or seeking valuable information relating to missing person, and best examples of general offer. And candidates standing for presidential candidates, prime minister candidates, ministerial candidates, persons who are standing for polls. So all these are general offers. That is it can be an individual or it can be a business entity, but they are coming up with an offer. It's if you selecting, if you are going to select me, then I'll be giving you these things. It's a kind of offer. They are giving it to the general public, and not to other business, and not to any other individual person. So that is called as general offer. So here the offer can be accepted by anybody if they are interested in the offer. So people who is believing in those words, so if they are agreeing to it, they can accept it. Clear? And then a standing offer or tender. So a tender, so we would have heard this word, a tender. Tender is nothing but an offer, a government offer. That is called a government tender. It is the government, or any business entity comes with an offer open to public, not to one specific person, or open to all the businesses of one particular industry. Say for example, if it's going to be an infrastructure, constructing a highway, a part of the highway or part of a road, from between, for say for 10 to 15 kilometers or to 50 kilometers, whatever it is, So there has to be a tender issued by the public works department, that is a part of the government, to the all the other contract workers, right? So all the contract parties who are ready to do the work for the public works department. So the finally who is going to get benefited is the public. So they will come with a particular price valuation, and the PWD department or the person whoever is in charge. So whichever, whoever. So if they are okay with one particular party's proposal, then they will accept the contract, accept the offer, so accept the tender, and there will be a contract made. So it may be either a definite offer or a standing offer. If a person tendered to supply specific goods or to tender specified services to the person who invites the tender, such tender is called the definite offer. That is particularly called. So, for example, ABC company invites tender for the supply of 100 tables. So, ABC company is like is in requirement of 100 tables. So, they are like announcing the tender. So, for this, this advertisement is inviting tender. It is not an offer. No, it is an advertising tender. So, JK and company submit the tenders or definite offer. So when JK and company, one company, submitting the tender, like that becomes a definite offer. If the company accepts the JK's offer, it is mean that it is a binding contract between the ABC company and this JK company. If the goods or services are required over a certain period, a person may invite such tenders. Such type of tender to supply goods or to tender services over a certain period are called as standing offers. When it comes to a certain period of time, say like after laying the road, like a toll road, like the road has to stay for at least for next to 5 to 10 years, right? So it cannot be like taken back in 1 year, right? So in that case, that becomes a standing offer. And then we have this like counter offer. When some changes are made by the offeree in the original made by the offerer. So it is called the counter offer. That is, one party has come with an offer. The other party who is going to accept the offer wants some changes in the offer. So that person, the other person is not okay with all the like guidelines or no regulations or whatever is mentioned in the offer. So the other party will accept the offer if there are few changes made according to the other party. So in that case, it becomes a counter offer. So over the counter, like these details will be discussed between both the parties. And the first party who is a like offerer. So first party who is coming with the offer is the offerer, and who is going to agree it is the offeree. So if the offerer is accepting to the terms and conditions by the which is proposed by the offeree and is ready to change like few things in the tender or in the offer, then that becomes the counter offer. So anyhow the tender has to get like accepted, right? The offer has to go for approval. Then only like the other agreement and contract will be like following thereof. So for initial agreement, initial acceptance, the offerer like accepts whatever the offeree is like asking for. So this person wants to make some changes in the original offer. So this counter offer will not become a contract. This will not become a contract unless the conditions given by the offeree are accepted by the offerer. So for example, A offers to sell cycle to B for 2000. So this is the original offer, and B makes a reply offering to purchase it for 1500. So if A is accepting for 1500, then that becomes the agreement and then becomes a contract. But if A is not accepting, then there is no contract made. There is no the offer is not accepted. So in that case, no agreement is even made. So in this case, B's reply is not acceptance, but is only a counter offer. And the seventh one is cross offer. If two parties makes an identical offer, that is like both the parties comes with an identical offer for the same subject matter to each other, it is called cross offer. None of them is aware of the fact that the other party is also making the offer for the same thing. So in the case of cross offers, they shall not institute acceptance of one's offer by the other. So see, one party is like coming with an offer, without knowing the other person's intentions, other person's acceptance, or other person's what that person is actually like requiring for. And the other person, anyhow, this person, there is no person B wants to go with the business, and without knowing A is going to make an offer. B, on the other hand, directly approaching A for the same offer. Okay, so both the parties don't know that they are going to contact one another for the same kind of an offer. So in that case, the offer becomes a cross offer. And we have to note this point. Uh, None of them is aware of the fact that the other party is also making the offer. In the case of cross offers, there shall not institute acceptance of one's offer by the other. That is, if both the parties comes with the same offering, that is, A is coming with a proposal to B for 2,000, and without knowing this, B is also approaching A for the same 2,000 offer. So in that case, both the parties know they are going with the offer. They accept it. Or otherwise, B knowing that anyhow A is coming with the proposal, and B now wants to change the mind and wants to go for a counter offer. So instead of 2,000, B wants to go with only 1,800 or 1,500. So that doesn't become a cross offer, but it becomes a counter offer. So here A writes, it's an illustration. A writes to B agreeing to sell car for 1,50,000. Then on the same day, without knowing this, B writes to A agree to buy A's car for the same 1,50,000. So both the parties are unaware of the letters written by one to the other. So both are not completely unaware. So this is not regarded as a contract. This without knowing one each other's offering. So in that case, when B receives after contacting A, when B receives agreement, when B receives the offer from A, and A receives the offer from B document, it cannot be considered as contract. Clear? So contract is something, a document, which has few specifications. There should be a government seal. There should be mentioned in this notary paper. Some notary has to attest to that agreement, and stamp duty has to be collected. So all these things are there. Stamp duty has to be affixed on the agreement. So then only when that is done, it becomes agreement, becomes a contract. So though both the parties share the offer letter between each of them, so that cannot be considered as a contract. Yep. So we have seen, as of now, we have seen, I think uh almost yeah. So almost everything, void agreement, voidable agreement, what is contract all about, and legally enforceable document, and illegally not enforceable document. How an agreement becomes a void agreement, and when it becomes a voidable agreement. So this can be confusing. You have to make it very clear. Void agreement is something where when there is when whatever is mentioned in the contract, so that is not followed by either of the party or by both the parties, whichever is mentioned in the contract, so that becomes a void contract. Voidable contract is something when that is something when there is a illegal business happening. There is which is not supported by the government, which is considered as a criminal offense by the government, and the government has restricted such kind of business activity. So in that case, even both the parties comply with everything whatever is mentioned in the agreement document, that cannot be considered as a valid contract, but that can be considered only as a voidable contract. It is not a void contract, but that becomes a voidable contract. So that don't those things are there. You have to have a clear understanding. So first thing, so in business, usually every a contract it starts with an offer, then that is accepted. when acceptance happens, no, like offer plus acceptance, that becomes a promise. And this promise plus consideration, considering all the factors, that leads to the agreement. And then when this agreement is no like enforced by law, that is no like comes under law by no like affixing the stamp duty and no like an attestation by the notary public, whatever it is, when that is done, so that becomes enforceable by law and it becomes an agreement. And the two rules, that is all the contracts or agreements, but not all the agreements or contracts. And another rule also, no, like we have seen. Okay, all illegal agreements or void agreements. All the illegal agreements, which is no like whatever mentioned in the agreement, if it is no like illegal under government law, so it becomes a void agreement. But not all void agreements are illegal. The agreement can become void, the contract can become void in other cases as well. So say, like if A is coming with a proposal to B, to have a like a business relationship for like selling and like selling goods. So A offers B, that A is ready to sell goods, like at the rate of say 15 rupees per unit, 15 rupees per unit, and like A is ready to sell, like 10 units, 10 such units. So in that case, so it becomes 150 rupees. Okay. So then B is like agreeing to that and is ready to accept the offer, but is not ready to pay the cash immediately. So B is asking A to first initially send the goods. So after the no receipt of the goods, B is agreeing to pay to A. So A is accepting this offer and then no like proposal and no like A is no like sending the goods. The same, whatever is said in the contract. So 10 goods, that is 10 units at no like 1 rupees 15 per unit. So it is being sent to the B. So after receiving the goods, no like B has not paid. So as per the business, any trade happened, no, like the uh, the the money for it, no, like whatever no the B has received, whatever the other party has no like received, the money has to be paid within a maximum of 9 months. And if it is no going more like going beyond 9 months, then that becomes no enforceable under law. So the other party can wait maximum for 9 months. But in case, on the other hand, on the agreement, if it is mentioned, on the contract, if it is mentioned that after the receipt of the goods within 3 months, B has to know like pay the amount, then yes, B has to pay the amount. Like B cannot say no, like anyhow I have 9 months. No, as per the government's rule, I have 9 months, so I can take my time till 9 months. You can wait, and then I can make the payment. So no, that is not no like a legal statement at all. Since the date and no like everything is clearly mentioned in the agreement or that is the contract, so B has to comply with that. So B is not complying with that, no like then that becomes a no like a void contract. Void contract in the sense no like completely it can be no enforceable under law. I mean the law can no like take it as void and no get compensation for A, or make B to go on no like with doing some kind of no like a business activity, that is no like making other processes no like completely free of cost for the sake of A, so that A doesn't get no like doesn't meet any loss no like in the business activity. So many things, no, like immediately the law will not, no, like make the parties, no, like sent to jail or no, like register them under criminal offense or no, like restrain them from making any business activities. No, that will not happen usually. So to the maximum effort, no, like the law will see to that, no, like the other party, either of the both the parties are not getting no like any loss. So they will try to see that no, because business has to happen. Only when trade is happening, no, like that generates money for the country. So that is the no backbone, the economic backbone of the country. So to boost the business, to know like go with the business flow and to know encourage the business activities among business entities and know like people, individuals. So governments don't know like law firms know like don't usually they don't directly know like suppress know like the party who is involved in the business activity. Maximum they try to is give try to get both the parties benefited out of the business, benefited out of the trade which has happened. So we will cease here. As of now, we still have yeah 5 minutes more. So if you have any doubts, you can ask. And please make sure you're muting your audio as soon as the session has started. Because all the background noises, it disturbs the class, to a great extent. The first thing is the flow goes off, and not only for me, for other participants as well. So why do everyone has to hear what is happening in your background? There is no such need, right? So make sure you are muting your audio. Yeah. Okay. So I'll stay here for 3 to 4 more minutes. If you have any doubts, you can ask. Otherwise, you can leave the session.
Hello, ma'am.
Yeah. Yes.
Hello. We actually had I entered the class little delayed. So will I get the recorded session later?
Yeah, I think so. Yeah, they are recording the session, so you can
Okay.
check with the coordinator, the academic coordinator. So yeah.
Okay. Okay. Yeah. Okay. Thank you.